Fulton County District Attorney Fani Willis will face a court hearing next month over allegations that she engaged in an improper relationship with one of the lead prosecutors in the Georgia election interference case against former President Donald Trump. Co-defendant Michael Roman made the accusations in a court filing last week, alleging that Willis was having a romantic relationship with Nathan Wade, a special prosecutor she hired in the case. Roman called for both of them to be disqualified and for the case against him to be dismissed. Willis is now accusing Wade's estranged wife of interfering and trying to obstruct her case. She has been subpoenaed to appear in Wade's divorce case next week. Willis has not confirmed or denied a relationship with Wade. A Fulton County judge has asked Willis to respond to the allegations by February 2nd. So for more on the case and other legal issues former President Donald Trump is facing is CBS News legal contributor Rebecca Roiphe. Good to see you again, Rebecca. So we're going to start with Georgia. When I first heard about this case, it's kind of salacious, but I thought, how bad could it be? But then Ricky Kleeman, kind of suggested that this could actually be quite problematic. What's your take on this Georgia case?
I think it casts a shadow over the prosecution, and for that reason, I think it is problematic. I think in terms of the legal consequences, it's unlikely to have any. I mean, this is like petty official corruption, if it's true. We don't want our public officials giving out benefits to their friends, lovers, anything like that. That's wrong. That's corrupt. Everybody knows it. The question is, would that affect anything in this case, the rights of the defendants in any way? Would it even appear to affect those rights? It seems unlikely that the court would draw that conclusion. And, Ricky Kleeman is absolutely right that there is that appearance of impropriety standard. So perhaps the court will be overly cautious and use that, but I doubt it. I really think that this is going to have a public relations hit, but not much of an effect on the underlying cases.
All right. And so let's talk about these cases, these efforts to keep Donald Trump off of primary ballots in different states. Donald Trump's legal team submitted a brief to the Supreme Court yesterday saying Colorado's effort to bar the former president from the ballot, talking about that rather. What is your takeaway from this? I think that the phrase was that it would create something in Bedlam. I can't remember. Chaos in Bedlam? Anyway, it was very, it was very like comic strip writing. What's your take on their argument?
Right. So, I mean, they're basically sort of essentially three arguments. The first is that he did not engage in insurrection. The second is that he is not an officer, which is the word that's used in Section 3 of the 14th Amendment, so that this amendment doesn't cover him at all anyway. And the final argument is that in order for this to have any effect, this provision in the Constitution, Congress has to act. And that's I think, their strongest argument. And if the Supreme Court reverses, I think they'll reverse on that ground. First of all, because it means that they don't have to get all embroiled in this question of whether January 6th was an insurrection and whether he engaged in it, but also because of that argument, which he made in those colorful terms, as you say. But if there is no centralized way of implementing this provision, then every state could act differently. And former president makes this argument, like, why wouldn't some political actor in some very blue state just, go after him? And the reverse could be true in a different situation. And so I think that's the argument that he's trying to make. And I think it's a pretty persuasive one, or at least the most persuasive of the ones he makes.
All right. So on to Trump's federal election interference case. The judge in that case indicated yesterday that the March 4th trial date is unlikely to hold. I'm sure that Trump's team is happy about that. They always want to keep pushing these dates further and further down, maybe till after the election. But why is it unlikely to hold? Why can't we, have these sort of cases that are really rather important in an election year? Why can't we have it on time?
Yeah, that's a really good question, Anne Marie. And I think that there's no reason to think that this is going to be a delay that will push the case off past the election. But there are appeals pending. There are just so many legal issues, it's hard to keep track of. But there is another argument about presidential immunity that is now before an appellate court, and that will likely be appealed to the Supreme Court too. And these things take time, but as long as all of the judges involved have in mind streamlining the case, I don't think that delay will end up being fatal to the case.
All right. Rebecca Roiphe, I got about 7 other questions here, but clearly we're running out of time. I know we're going to talk again. Thank you, Rebecca.